This is the Law y La Ley, a podcast on the Constitution and the Supreme Court from the perspectives of scholars of color. I'm Craig Jackson, a professor of law at the Thurgood Marshall School of Law at Texas Southern University in Houston, along with Professor Heriberto Román of the Florida International University School of Law in Miami. Dr. Laura Cisneros is an affiliated scholar at the University of San Francisco School of Law, coming to us today from Oxford, England. Today, we continue our discussion of important cases handed down by the Supreme Court's recent term. This week, we discussed Trump versus Slaughter and Trump versus Cook. Both cases address whether the president has the power to fire principal officers of independent agencies at will, or must the president establish cause before those officers can be terminated. Trump versus Slaughter dealt with the Federal Trade Commission, the regulatory body that acts to prevent business fraud and deceptive, unfair business practices. President Trump fired two Democratic commissioners of the FTC summarily without a statement of cause as required by the congressional statute governing the commission. One of the commissioners, Rebecca Slaughter, brought this case claiming primarily that the president did not have the authority to fire her without cause. The court decided that he did and that the FTC statutory removal clause is unconstitutional, and it overruled a contrary decision by the court, also involving the FTC from 90 years ago on the basis of unitary executive theory of the Constitution. Under that theory, in order for the president to be accountable for all executive actions, the Constitution gives the president the authority to fire at will officers of independent agencies exercising executive power. In Trump versus Cook, the court looked at what it considered a special case of the Federal Reserve and ruled just the opposite of what it held in the Slaughter case. It ruled that the Constitution does indeed protect governors of the Federal Reserve System from removal absent cause, contrary to the position it took in Slaughter, because in essence, in the court's view, the Fed is different because its work is in monetary policy. And that's one of the things, my brief take on this one is basically, these two cases together, it's basically, I find the Trump versus Slaughter case to be probably a good decision if the court, the decision of the court written by Chief Justice Roberts, is accurate on the history. There's a bit of context that I'm concerned about here, and it appears that the court relies heavily on something called the Decision of 1789. That was the first act by Congress to establish it's the first cabinet officials and the first cabinet officers. And the first cabinet office was the Department of Foreign Affairs, which now is the State Department. The court draws a lot of analogy from the Decision of 1789, which doesn't specifically give the president at will firing power, removal power. But it does seem to give, and many scholars do believe that it did give the court, the president, at will removal power. The problem is that the decision of 1789 was about cabinet officers. These issues in Trump versus Slaughter and Trump versus Cook are about independent agencies, a separate category of office from the cabinet of the United States, of the president, essentially. So those officers, the secretaries of the various departments, are of course fireable at will. Now, when it comes down to the issue of Trump versus Cook, I'm also concerned about the way the court went about its business here and basically decided that with all the history that it looked at, that they were going to look at the monetary policy agencies. There were several in the history of the country, beginning with the first year after the Revolution. The Department of the what is it called? The Department of Monetary Policy of North America, essentially, and then the Bank of North America is what it was called, and then of course the first and second banks of the United States. Those banks were set up, according to the court, to be fairly independent and free of political motivation because they dealt with monetary policy. Well, why isn't that history indicative of the overall history of the court, of the Congress, when it comes down to all the other positions of independent agencies? In other words, why does the court in this particular case decide in Slaughter that the history dictates an at-will policy for the president, but seems to ignore in those cases where the history indicates just the opposite with regard to monetary policy agencies such as the Federal Reserve System. Laura, you want to take over?
Sure. I think that was a great lead in, and you've touched on so many things that I had also found very contradictory and very confusing. And so these opinions they seem to pull, as you say, in opposite directions. And so I think it's fair what you said about Trump versus Slaughter, in the sense that if Roberts is right on the history, then it looks like an internally coherent decision. But then when you get Trump versus Cook, and you get it being pulled in the complete opposite direction, with its doctrinal question basically being, well, why is the Fed different? To me, the most interesting question then is why history becomes fixed and controlling in one case and living and adaptable in the other. And so as I was going through the opinions, and they argue kind of at bottom about what a tradition is and how the past should be permitted to act on the present. And so when I look at both of these cases and kind of read them side by side, to me it suggests much more than simply redrawing the law of presidential removal power. It really does expose the court's historical consciousness, essentially, right? How it understands the relationship between history, tradition, and constitutional authority. Because, in Slaughter, you get the 90-year-old precedent, and it's treated like a mistake that the court can simply erase by returning to some, historically constructed constitutional settlement that, I don't know how many different ways Roberts tried to reframe it, but however he did so, I was like, that was a minority of the people. They lost that interpretation in 1789. And so in the other case, you have a 200-year-old institutional tradition, which is, understood by the majority as capable of changing form, while still retaining its constitutional identity. And those two things just don't match up to me. And so for me, the unresolved question is, what tells us when the past has to control the present? So when does tradition have to be restored to its origins, whatever that means? And then when is the court allowed? When does the court allow the past to evolve in order to preserve an institution that it believes, for some reason, the present still needs? So I have a lot of questions about these cases.
Hey, Roberto?
Yeah, I tend to agree with both of you. I'm going to be a little bit more perhaps critical from a separation of power standpoint and a for lack of a better way to describe it, a political standpoint, right? And these decisions are really tough to understand outside of the realm of politics, right? When we look at these questions, there is, particularly in this day and age, and this under this administration, there's cynicism with motivations here, right? Particularly in the context of Cook, and questions in terms of monetary policy that seem to be divergent with the executive, and should the executive have the authority with respect to, my general reaction from a separation of power standpoint is that Cook and Slaughter should have been decided the same way. From an separation of power administrative law standpoint, you either go, for the cause requirement or you don't. I think there is a strong argument in light of this court, in light of the philosophy that they have of a unitary presidency, to allow the president to do such things absent some checks, right? That we've seen in other settings, and with either fundamental rights or something explicitly rejecting it. So it's, confounding in the sense of trying to teach this stuff, to say, hey, how do I teach someone black letter law when so much of it seems to be at the whim of the court in both these settings? So I'm troubled by it. My inclination, frankly, would have been to allow the president to have the power in both instances in light of what they've done in the past. Not something that I would do if I had my druthers and a majority of the court. But looking at what the court's done, it seems to be given, right? They're called independent agencies, and, we talk about the fourth arm from an administrative law standpoint, the fourth branch of government or fourth arm of the government. And we often fail to realize that these agencies are there to effectuate the goals of the executive. And then the checks that are put on them by Congress, does that run afoul? Well, Slaughter seems to suggest that they do. And then Cook seems to suggest that it shouldn't. So finding coherence in these opinions is very, very frustrating. And I'm left with, you know, it's what they feel like saying now in this context, monetary as opposed to, others. I think of Savalas and how far they went to find taxing in a tough setting. So, you know, he's exacerbating to say the least.
It seems to me that the Chief Justice Roberts is adamant about this unitary executive theory, and the idea behind the unitary executive theory is that the president gets to control everything that happens under his or her watch as in the executive branch. Um, and that sounds good. I just don't think that the history is convincing. I'm not saying it's not the history is wrong. I'm just saying it's not convincing because the argument that Chief Justice Roberts puts together is basically we don't have a clear statement anywhere in history as to this principle other than Myers, which was a case decided 10 years before Humphrey's executor, and just Chief Justice Taft decided that yeah, the president has full power to fire at will any executive officers. That's the first time any branch of government made that statement clearly. In the Myers case in 1925. So that's we're looking at taking language from the Federalist Papers, Hamilton, and taking language from the debates, which of the Congress, which is called legislative history, by the way, when they were establishing the decision of 1789, which I thought that conservatives weren't supposed to do, but anyway, they did it. So we're looking at the legislative history of the decision of 1789, and that statute does never say clearly that the president has free, uninhibited removal power. Scholars think it did, but you look at the language of it, which I don't have to repeat here, but the language does not essentially say that. So we're relying upon Hamilton's language in the Federalist Papers and other examples of outside of Congress and outside of the court statements by prominent persons. George Washington, for example, about as prominent as you get in our legislative and constitutional history, about the need for the president to have full control over the executive branch. That's how I think that this thing comes up. And I think Justice Sotomayor talks about that. The history, the evidence is light on this case.
Yeah, I mean, I appreciated Sotomayor's opinion because, I read her as kind of taking the the historical framework that the majority put out there, taking it on board. And she's like, fine, if you want to use this idea of Madison's liquidation and practice in order to identify, and settle and clarify what something means, then that's fine. But she's like, but you have to keep going. You can't simply pick an arbitrary stopping point and say, well, no more history or historical practice from this moment forward,
Right.
because then you end up just erasing entire chunks of the historical line. So I really liked her opinion for kind of taking on what the majority had set up and showing where the flaws were. So you mentioned two other things, Craig, in your comments, and one was it got me into thinking about Kavanaugh saying the quiet part out loud, just going, well, we just really need to figure out from an instrumental functional standpoint, what the right thing to do is. And we just need to, it's about risk. It's not about constitutional truth or authority. He's just like, well, let's just see kind of, and like, that's not how history works. And to her credit, Justice Barrett writes that out and says that's not how history works. You can't just say one thing on Monday and a second thing on Tuesday, because it lines up, Eddie Berto, as you were saying, with a broader political policy, or Craig, like you were saying, with a appreciation for unitary executive theory. You can't keep switching it around like that. And then the final thing I'll say, just real quickly, is the use of history in the pieces that you were talking about, Craig, that Roberts was stitching together for his argument in Slaughter. I actually think that this is one of Justice Thomas's strongest opinions in terms of the historical architecture and the archival account that he is putting up to match Roberts in Roberts' construction of history, because and what I like so much about it is his use of that counterpane metaphor about just pulling over the cover on a bed because you don't want to see what's mussed up all underneath, and him using that in the Cook opinion to refer back to a line that Roberts writes in the Slaughter opinion about this historical continuity. It's just, I thought it was it's not just a rhetorical device, because the image is actually making the argument that Thomas is following through in the rest of his opinion. So I thought that kind of head to head was interesting to unpack.
Yeah, I thought, well, Roberto, you wanted, I had some thoughts, but I wanted to go ahead and let everybody speak on that.
Go ahead, Craig. Feel free. I have some thoughts on a more macro scale, so I'm looking forward to hearing your comments.
Yeah, it's this history. First of all, these guys are playing fast and loose with originalism, but Lord help the jurist that doesn't follow originalism, because of course we're all liberals, are all trying to make up laws as we go. Judges are not supposed to make legislation, make up laws. They're supposed to just follow and play baseball. I mean, umpire baseball, I should say. It's an inside joke. But essentially, the idea that you can go back and forth with your originalism, use it, as you said, Laura, sometimes use it and sometimes not use it, it's troubling. It's really troubling. And of course, the distinctions between the two cases, I think, highlights that. But my big question has always been, with regard to the unitary executive theory, I think that Chief Justice Roberts gave a very fine history, at least a description of the history. Whether it's accurate, that's another matter, but a nice, I guess, exposition of where all this came from and how all of this started. Going back to the history before the revolution, during the revolution, and after the revolution. And all that was very helpful and interesting, seeing a bit of content. What I've never, though, understood, though, with regard to the unitary executive theory is why men who suffered under an all-powerful king, King George, would create a semi-all-powerful president with regard to removal. And I've never quite understood that, why we have Hamilton's words in the Federalist Society. Did I say that? I'm sorry. I mean, the Federalist Papers. Excuse me. Excuse me, Federalist Papers. But it doesn't seem to me that, and there was also dissent on a lot of these executive power issues as well during the debates for the Constitution in Philadelphia in 1787. So we have come to conclude with this case that there was some kind of strong agreement among the framers that this semi all-powerful executive is important for our democratic republic. Despite the fact that they fought a war against an all-powerful executive, the king of Great Britain, this a decade before. I'm not sure I've ever understood that logic. Does anyone understand it?
Yeah, I mean, you raised points directly related to what I was thinking. If you think about our last three podcasts, right, in the context of the Second Amendment, birthright citizenship, and now the power removal of the presidency, uh, the court is all over the place. I think what we're witnessing in terms of the critique of originalism, this will be an era where, and I don't obviously don't know where the court will go in the future. I'm talking generations from now, what bent it will have. But this will be an opportunity for constitutional scholars and pundits to criticize this court, much like um, the Douglas Court or other courts, right? More liberal courts of the 1960s and 70s were criticized because of their basically what is tantamount the intentionalist or living document philosophy and the faults with it. Here you have a fairly consistent, right, 6-3 majority of the court. Not always, as we saw in the Barber decision, but for the most part, you have a 6-3 breakdown. They go along what is viewed to be the party or philosophical lines, and yet they're all over the place in terms of their theory. And we have this. This is a quintessential example in the removal context where we say FTC, okay, unitary, right? Monetary policy, not okay. And then picking and choosing history. And I think Laura's point with respect to the difference between the Thomas and Roberts decision, something we raised before, and how jurists and legal scholars are not the greatest historians. So I think it's going to be fodder for criticism, right, in the future, in the lack of consistency, because once again, looking back just a little over a week ago, when we look at Alito and his, contemporary use of issues related to immigration, boy, did he sound like an intentionalist. Did he sound like a liberal seeking a conservative end? And in this context, it's somewhat tough to figure what their motivations were in terms of what's going on, because they wanted to go straight conservative, right? Slaughter and Cook would have been decided the same way. I would have preferred, instead of the picking and choosing of history and how you use history, if they would have stuck to separation of powers grounds and under the unitary presidential or executive doctrine, and basically said, essentially, absent a fundamental right, absent something that it's explicit in the Constitution, we're going to allow for this authority. And you still suffer with that philosophy, right, Craig? You still suffer with what you're troubled with in terms of the origins of this country and providing what is tantamount to a king. I just wonder how much when we're frustrated with these opinions or we're motivated by a certain disdain, right, for the policies behind them. It's hard to separate. We're told to do it all the time. In my state, just this past week, we had a federal judge struck down the Anti-Woke Act that prevented professors from providing any political views in the classroom, which I think is absurd. We are always providing political views, even if we don't couch them that way. But that in and of itself, right, is a left-leaning concept, a more Foucault type. I was going to say Foucaultian. I don't know if that would work. Type analysis, but this court. I mean, it's hard to figure what they're doing. Heads or tail. The bet is they're going conservative, right? Unitary. But if they were going to go full conservative, Slaughter and Cook would have been decided the same way. And it's really hard to try to provide consistency and a coherence to their analysis, other than to say, is it politically driven with some checks, some fears? I don't know.
Yeah.
Yeah, you so hit the nail on the head for me with your comments, because what did you say? Consistency and coherence. That refrain keeps coming up for me over and over again. Because I think the first point that you made about originalism now going to be coming under critique, I think that that's a train that a lot of us saw heading for, the side of a mountain, right? Because this idea that originalism, critiquing the selectivity and the discretion of the Warren Court judges and the liberal judges, and then finally getting their moment in the sun and laying this history and tradition, historical analog, methodology, all over constitutional law. I think now that these cases are coming to them, they can't come up with, because quite frankly, there isn't a principled, objective, always approaching this kind of way to use history, because history is contingent. And every time we do something in the present, it shapes and shades what came before and what possibly can become in the future. And they have this, I thought it was just so perfect that the image that they brought up was this, what was it, something trapped in amber.
Yeah.
And I'm going, that's exactly what you told us all, originalism and historical and history and tradition method was meant to do. Go back to that origin point, that moment trapped in amber in Liberty Hall, and figure out what something was, and then just pull it forward and drop it into the present. Well, they're finding now that that's not working, and it's causing them to write from a just internally incoherent manner. It's causing them to poke holes in jurisprudence in a way that is making it look like Swiss cheese, because these opinions that are all dealing with similar issues are not aligning up with one another in terms of how do we approach them. And it's causing some really, really big problems. And I just had to say, for one quick moment, when I got to Alito's opinion, it not only did it give me pause, but it angered me just a little bit, because he was talking about, this isn't the right time. This is an opinion that's come to us, and we should have just let it be decided. They could have decided it on narrower grounds, and all very reasonable and valid things. But in other instances, he's perfectly willing to go ahead and take something up before the record has been fully developed before. And so it was just infuriating.
Wow, you got infuriated by Alito. you know, yeah, I agree with the point about originalism. Originalism, that the stuck in amber line. Or when I read that, I'm thinking Earl Warren could have written that. Thurgood Marshall could have written that. William Brennan could have written that. Believe me, these are the most living document justices of the last during the 70s and 60s and 50s. Those guys are really
yeah, and that's why history won't be kind to them, right?
Yeah.
In light of their professed, right, self-professed, right, mode of thinking or philosophy, constitutional interpretation. Yet, when it suits them, they seem to be naked politicians, and that's what's troubling. I think I guess I'd have and something we mentioned last time. Could it be that they don't have the gravitas to stay consistent with their theory? But even those that I mentioned last time, particularly Scalia, he was inconsistent with his rejection of legislative history. Now they're just picking and choosing to the ends they want. And I would just prefer different philosophies with respect to the separation of powers. I could understand Slaughter and Cook from the standpoint, again, not so much the unitary executive theory as much as a hard line executive separation of power, analysis of what is the role of the presidency and the power of and the necessity of expediency in the decision making. And that I find that I tend to find that persuasive in a host of different settings. And you folks may be able to convince me otherwise, but I don't see a lot of difference between monetary policy and FTC policy in terms of importance vis-a-vis the executive. And if your view is of a unitary executive theory, why not decide these things the same way as opposed to struggling with the appropriate history when even fellow conservatives are one sounding like liberal and the other in Thomas's opinion that you pointed out and does a nice job. And he's can't 100% be sure it's him, but as with any justice, whether how much it's the clerk, but beautifully written piece, but as far as being consistent with prior positions, who knows, right? When it comes to him and others, but this court is it's hard to figure. I see it with Loper Bright in the agency policy and the deference there. So, Loper Bright and their conservative philosophy of the majority suggests to me these decisions should have been addressed in the same fashion as opposed to picking and choosing history. And we pointed out on more than one occasion how they don't always use history. At least they don't use it exhaustively. And these two opinions highlight that in terms of the line drawn by Sotomayor or Justice Thomas in their respective opinions.
Right. I think that where I look at it, and I hear what you're saying, Edilberto, but where I look at the situation is that in Robert's opinion, he doesn't recognize that the history goes both ways, because you do have language from the prominent people of the framing era that suggests that monetary policy is different. Okay, but why? Essentially, why is monetary policy different? So basically, and then you have statements that suggest that the president should have ultimate power to fire anybody he wants to. Well, that tells me right there that history is not conclusive on this issue. But I do want to talk about. I don't want to raise.
Is that what? I'm sorry, I didn't hear that.
It's not conclusive on this issue.
Conclusive. Thank you.
Yeah, and that's the point I was making. But on the other side, may I introduce what I think to be the most interesting opinion in this group of opinions? That is the opinion and concurrence of Justice Gorsuch, which to me reads like a dissent, except for the fact that he comes to the conclusion that we are now closer to the correct interpretation of the Constitution. But he says basically that this opinion causes problems. After the Humphreys executor case, the Congress went about the business of just going hog wild in creating new independent agencies and giving them judicial power and legislative power and executive power, if you consider that executive power. And now what Gorsuch is saying is that now basically the president not only has control over executive actions by these agencies, he now has control over legislative actions by the agencies, and he has control over judicial actions by the agencies. Now, we got cases all over the place that says that the president may not do legislative actions as well as judicial actions. Can't do those if you're president. So basically what the court has done, majority has done, they've created a new unconstitutionality. And Gorsuch talks about that in the opinion, because essentially it is a violation of the doctrine of separation of powers for the president to have control, effective control over judicial and legislative decision making. But lo and behold, now the president does.
Yeah, Gorsuch's opinion was interesting. When I started going through it, he agrees with, every doctrinal step that the majority is making in Slaughter, but he kind of writes what I would characterize as an intellectual history, almost a sociology of ideas rather than a doctrinal analysis, right? He's, as you were saying, tracing this administrative state to specific, nameable intellectual movements. He's pulling in Woodrow Wilson, James Landis, and all of this stuff. Bring in the Prussian bureaucracy because why not? But his argument is genealogical, right? Independent agencies are not a neutral technical adaptation to modernity, but they are the residue of an ideological project that the Constitution's structure, according to Gorsuch, was built to prevent. So he's seeing the application and the purpose and function of the Constitution in a very different way than our jurisprudential history would indicate. And so where Roberts is using history to fix doctrine, Gorsuch is using it to actually diagnose, right? He's actually doing this idea of, what is wrong with the larger structure and the larger framework. So I read his intervention as much more disturbing, because if you take him at his word and you follow his logical, follow him to the logical conclusion, right? His prescription is to revive the non-delegation doctrine, the major questions doctrine, Article 3, jury protection. And so it's not just, limited to the removal holding, but to essentially finish undoing what he sees as a coherent decades-long project of constitutional evasions and constitutional mistakes. I find it very radical.
Well, to the extent, well, this is my take on it. He's saying that basically Congress has to act to take away these powers from the president, the legislative and the judicial powers. And you do that through separation of powers theory, do it through major questions doctrine theory, whatever it takes, but it has to be done, because right now the president is, right now the situation is just plain old unconstitutional. And the president has already acted. The what is it, the Elections Assistance Bureau or something, that he fired everybody just 2 days ago.
Oh.
Yeah, he actually used that, and his new powers under the Slaughter decision. But to the extent one day he's going to fire somebody for a legislative act in one of these independent agencies, or for a judicial act in one of these independent agencies, and then you have a problem, because that would be unconstitutional. But this court, in this case, the majority has said, that's okay, despite the separation of powers doctrine.
Yeah, I guess I take somewhat issue with that, and here, and I'm finding myself doing it more than I like, frankly, going a bit more right than the two of you at times. It's how one interprets these agency actions, right? From a pure separation of power standpoint. I'm not sure I'm completely there with Gorsuch. I like his methodology. I couldn't get that word out. And I just don't completely agree with him from an administrative law standpoint. See, I view these agencies, whether we look at them as, essentially independent agencies, legislatively created agencies, they're all effectuating the goal of the executive branch. And yes, they have component parts that are rulemaking, right? That are decision making, executive, normally associated with executive determinations. They also often have judicial components to them, right? And in terms of this, but I don't see them perhaps the same way you two do. I see those as functions to effectuate the goal of the executive. And if you look at it from that standpoint, perhaps a dare I say, a conservative administrative law standpoint, They are achieving the goal of the executive, and shouldn't the executive therefore have the power to have someone in those positions, right? To determine the goals in the fashion that the executive wants. Right now, we may not like it. I think, every study that I seem to be reading, every poll that, MAGA is disintegrating, but how much is our disdain of these opinions, right? The lack of consistency, I'm totally with you. But in terms of the unitary executive power doctrine, how much is that turning on either explicit or implicit disdain for the current president, as opposed to more a separation of power standpoint that essentially these agencies, right, stem from, they're not called this, but they are executive agencies. They are effectuating the goals of the executive, where Congress legislates, right, passes a law, not being exhaustive with respect to these issues. The goal of the president is to effectuate the law. And you look at it from a separation of power standpoint, these agencies are to implement those goals that the executive is supposed to execute.
But are these
And
executive
as such, shouldn't the executive have authority over them? So I would have probably, decided to cook differently, and from an administrative law standpoint, say the executive has these powers. But I'm open to be convinced otherwise in terms of the tragedies associated. But at least I think that standpoint is a bit more consistent, from a separation of power standpoint. It's certainly better than this historical. It's a historical analysis that we too often see, that we've seen in a variety of episodes of this podcast, and certainly in this setting. So I guess my view is slightly different. And the non-delegation doctrine, I hear you, which I suspect would be a response. I hear you with respect to that. I'm not sure I buy it. Thoughts?
Oh, well, I was going to say, I was simply explaining what Gorsuch's opinion was. I wasn't saying that that's the train I'm on. So I'm not sure in putting, so I just want to clarify that. I was simply giving an analysis of what he was doing and what his position was. But to be fair to that point, I think what we're seeing, or at least what I'm seeing, is that we're, I think part of the frustration is that, excuse me, we have these concepts that seem to be either or, seem to be very one way or another. And for right or for ill, that is not how our jurisprudential history has developed. That is not how our political history has developed. And so in this particular moment in time, to be trying to put the genie back in the bottle in a way to say, well, we're just going to simplify things. We're going to go back to the beginning and kind of do a reset. Well, first of all, the Reconstruction Amendments were that reset. Second of all, I'm just not sure that we have the luxury to be looking at these complex, overdetermined, interdependent issues with a view toward a pure idea of separation of powers, a pure idea of unitary executive theory, a pure idea of non-delegation, because that, while ideally would be one thing, I think it in terms of the political reality in which we live, it's impossible. And again, I think through these decisions, we're seeing that impossibility manifest, because these justices are trying to fit these analyses and these justifications and these theories into a straight line. But as we see here, there's little to no agreement on this bench in terms of what history means, and more importantly, how it's supposed to be used.
Yeah, I would agree with that. We just dealt with two cases. There were two episodes of this program where we raised questions about the the earnestness of the originalism doctrine. And this case doesn't help that argument. At least, let me rephrase that. This case doesn't help their argument. It helps our argument in terms of the originalism doctrine. But one thing,
or these cases, right?
huh?
You mentioned these cases.
These cases, right?
Yeah.
But I would say though is that I do think that just to kind of shore up a little bit my esteem, and I really mean that for Gorsuch's opinion, is because I do think that we have a looming constitutional problem that the majority created in the Slaughter case in particular. But in terms of, you mentioned Edilberto, that these were executive agencies, and these agencies that essentially were pursuing executive goals and policies. I'm not so sure about that. And correct me if I'm wrong about this. First point, Supreme Court in Humphrey's Executor, and in my opinion, just because the case has been overruled doesn't mean that it doesn't exist. So Humphrey's Executor did say that these were quasi-executive functions. Justice Sutherland wrote the opinion. I guess he was a smart man. I guess Roberts is a smart man as well. So I'm not quite ready to say that these were idiots back in 1936, 35 when this decision came down. That being said, he said that the actions of the FTC, the very same agency in Slaughter, were quasi-executive, but not fully executive. It has some relevance there, I think.
Yeah, I think you're right. I think that it does have some relevance. Does it have coherence? That's my point, right?
It was coherent. It was coherent for Sutherland, and for 90 years it was coherent.
Yeah, it was.
Until last week.
This is why I think, from an administrative law standpoint, this court has struggled here, and the court has struggled even in Humphreys and its progeny, in making determinations when a president can fire. Is it senior, an officer, cabinet level? This line drawing, screams to the difficulty, not just now, but then in figuring out the role of these agencies, right? And I think, when you look at it from an administrative law standpoint, I think you'd have to look at these agencies as stemming from and flowing from the executive. Even if you're going to label it quasi-executive and this arguments on non-delegation doctrine, they're problematic to me, because as far as I recall, is if the legislative function is in Congress, and if they don't feel, and if they don't believe, they being either Congress or the court, believe that the policy determinations aren't made, then write better legislation, right? Because these agencies are to fill the gaps, right, that Congress didn't engage in when it passed the law. And the executive, the way the structure has historically worked, the executive is supposed to effectuate these goals. But how do you effectuate these goals if you don't have rules? So we create what is tantamount to executive agencies, right, in a host of different settings. But the administrative state has grown so large that we find, and we try to line draw, they're serving in a legislative function, a judicial function, an executive function in this setting. My standpoint is they're serving an executive function. I may not like the person that's in the office right now, but the person has that power, right? And when we are putting, right, this is where I would be a bit more conservative and stay with the court, at least not in Cook, but in Slaughter, and saying, if you're serving an executive function, then how do you not effectuate the goals of the executive if Congress can put a check on it, right? A for cause check on it. My view would be do away with a for cause in both settings. And yes, I may not like the determinations, trust me, of what's going on now and the motivations behind it, but that shouldn't be the determining factor. And I just worry that a lot of our critique, not saying the three of us, But a lot of the critiques of this court are with implicit in that they have a political motivation, stated or unstated, behind them. Because I think if you look at the administrative state as being an arm of the executive, then the unitary executive model is much less disturbing. That's just my view with respect. And there may be decisions that are made either now or in the future that I'm frustrated with and I disagree vehemently with on a personal standpoint, but from a constitutional standpoint or an administrative law standpoint, I think the executive should have these powers. Elections count.
I think you raised some really, really great points, and I actually caught some of that in Thomas's dissent, right? Because when you put something up like quasi-legislative, right? Quasi-legislative sounds like it's a real analytical category, right? That there's some process that you can apply, but it actually, as Thomas is basically, arguing, it's actually a camouflage for saying, we can't really say what kind of power this is, right? So we either go with executive agencies stem from the executive branch, and they're part, as you've been saying, and I do agree with that connection. Or you have to somehow define through congressional legislation more specifically what this body is, what they're meant to do and what they're meant to be in charge of in its own creation. And I think therein kind of lies part of the problem, which is when the branches are not fully functioning within their own sphere of power, you get these gaps and you get these developments. And now we're trying to kind of like untie the Gordian knot that we've created for ourselves, where, we're happily living for 90 years in this quasi-legislative analytical category. But when you place it right up against the distinct historical tradition that Roberts was constructing for the Federal Reserve Board, they don't cohere with each other, right? One is just as slippery in terms of what it means and how we identify what the distinct historical tradition is and what that means and what a quasi-legislative power is and what that does. And so when you get rid of one, as you say, Edilberto, it should follow that you get rid of the other one, and that's not what happens here. But so I think that these are pointing to larger structural problems.
Is monetary policy an executive function? I think I'm thinking I don't know the answer to that question because I'm not I used to be an economist when I was younger, but not anymore. I've forgotten all my graphs. But is monetary policy an executive function? I don't know that it is, but I think the thing is that what I would like to offer up for rebuttal or agreement is this idea that why is it so? I mean, if we assume that the history is not clear, and we don't have to assume that because the majority said it was in both cases. If we were to assume, however, that the majority is not clear, can we also assume that there is nothing so inherent about an executive function by an agency that's not a cabinet agency, by the way, but an independent agency created by Congress to be independent? There's nothing so basic that suggests that a president has to have full control over that agency. Because if indeed we agree or we don't agree, but if in fact monetary policy is an executive function, well then this idea of that Hamilton talked about when he opposed any kind of politics and monetary policy is basically irrelevant.
Yeah, I guess that's a tough question.
But let me make one more point though. The thing is that if we do give the president power over monetary policy, then we can suffer some huge calamities in terms of the economy. But if we didn't give the president authority over other aspects of independent agencies, would there be a calamity in those cases? Well, it hasn't been for 90 years since Humphrey's executor, so why would it all of a sudden be a calamity there? Now,
Well, that's a lot that you just posed there, right? That now is worth a discussion. But my gut reaction is write better legislation, right? Because the Constitution, right, is pointing to certain powers, right, in terms of Article 2, in terms of what was the thrust of the Slaughter case, in terms of the determinations that the president can make with respect to it. So, it is like, the passing the buck to the executive and then wanting it back, right? When my response to your question would be, does Congress provide us greater sense of security or stability in light of what we've seen, especially in recent times? Is that much of a check in terms of the executive? I mean, we've avoided calamity, I think, as much because of executive policy, Democrat and Republican, with the exception of Hoover and maybe what we'll see in the near future. I hope not. But I don't know that check is the end all be all that that we should have. And there's only one set of powers that I identified in the Constitution with respect to this executive arm or agency, administrative law arm of the government, and that's held in the hands of the presidency. So I don't know. How do it seems like the rabbit's out of the hat, so to speak, and now they're trying to put it back, and we find inconsistent positions in light of that. Using the quasi originalist historical analysis that I think the three of us has consistently found to be problematic.
Laurie, you want to have the last word?
Yeah, I just real quickly, I loved your line, Edilberto, about Congress just write better legislation, because I think that is one of the key takeaways of what we're seeing right now, that they have let the executive branch drive the regulatory bus for so long, that now we're seeing what that has led us to. So my final thoughts, right, is in looking at both of these cases, no single justice's kind of vote pattern across both of these cases can be explained by one clean and clear interpretive theory alone. And so, which to me seems to point to evidence for the argument that Justice Barrett makes explicitly and Justice Sotomayor makes implicitly, that tradition is doing outcome-driven work here rather than supplying any kind of independent constraint or objective touchstone, because both accounts of history from each case can't simultaneously be the court's actual method. Only one of them can be. And I don't know how this particular court is going to lean into one consensus history and tradition method.
Wow. Well, thank you very much, both of you, and for these thoughtful and you basically just, both of you have established that the opinion is rather perplexing, but maybe the outcome was right or whatever. The two opinions are different, and the scorecard is the president can fire the major officers, the principal officers of independent agencies, unless to deal with monetary policy, and there's only one such agency that deals with monetary policy, that is the Federal Reserve. Now, the next question that will come up at some point in time is whether or not rank and file employees of these agencies can be summarily fired. I used to be a rank and file employee of one of the cabinet agencies, or the cabinet departments, and I've been thinking all week I could have been fired. So I don't know. I didn't. And I was 30 years old. I was young. I needed a job. I don't know if that's going to be something I wanted to happen to me, but that's, I think, is the next issue, because at some point this president's going to want to fire a rank and file member. So we're going to come back with more cases from this term in the next few weeks or so. Please stay tuned to to this station, to this place, to the YouTube channel for That's the Law, the Law y La Ley. And we look forward to seeing you again in a couple of weeks. Laura, Edberto, take care.